Welcome everyone to the Savvy Ladies Wednesday Wisdom webinar. I'm Maggie Montemuro and I'm the Marketing Manager at Savvy Ladies. If you have any questions during the webinar, please type them into the chat box. If you're joining us by phone, you can email your question to info@savvyladies.org. Today's presenter is George Bischof, a wills, trusts, and estates attorney. George helps families with some of the most important aspects of financial and family responsibility. His approach to estate planning combines direct personal attention with legal expertise. Clients protect their loved ones while preserving their wealth. With proper planning, many of George's clients prudently address their estate tax exposure, leaving more for their family, friends, and charities. His commitment is not to make his clients experts in estate taxation, but rather to explain choices so that tax planning opportunities can be coordinated with investment, philanthropic, and family objectives. Thanks for being with us today, George, and I'll hand it over to you.
Great, thank you, Maggie. As I was listening to that, I realized it doesn't say anything about my tennis game or my bridge playing abilities. But yeah, it's mostly true. So let's jump in, and hopefully you'll, as you watch, have some questions, and we'll, as Maggie said, talk about those at the end. So here's my first slide. As you know, this is about estate planning. Let's jump in. Look, I'm not your lawyer, and you're not my client. This is a standard disclaimer, but please do heed it. If you have a particular idea or issue that gets raised by the presentation, you need to call somebody, do that. But this is general advice. So thank you, Savvy Ladies, for the forum to present it, but it's not a legal clinic. And that's not a George rule, that's just a how lawyers work rule. Okay, so estate planning is interesting. We've got a bit of a word salad here. I think my kids call this a wordle. It's not a wordle of this presentation, but it's a reminder to me to remember to speak in a way that is not lawyer jargon. And so I will try to do that as we go along. If you are a person with a very large balance sheet or very complex issues, you may in fact want to speak to an expert about some of the things here. But generally, this is also a reminder to everyone that a lot of estate planning is really about common sense and taking precautionary steps. Getting a will, getting related documents. It's a little bit like making sure that you have a spare tire in your car. So let's dive in. Overview. What are we talking about here? Estate planning is for everyone. It's not just for the very rich. It's not just for people who are married to a foreign spouse. I'll say this as candidly as I can. I say to everybody, you're all going to die. I'm going to die. We all are. And part of doing that elegantly, as the title of the webinar suggests, is not leaving a mess behind. And that means not only, not being exposed to taxes you could have avoided, but leaving a plan for those behind you, whether it's a plan to deal with stuff you own or care for your loved ones or to deal with a specific issue. And most of the time, estate planning can resolve those. If you have a long-seated dispute with your brother, estate planning may not fix that. But, if you want someone to take care of the book you've almost finished or a lawsuit you were involved in, or make sure that your family summer home stays in the family, that we can do. But if you want to do those things, often having a will is not enough, and you'll need some other documents we'll talk a bit about. There's the power of attorney, healthcare proxy, and living will, and we'll go through those. And then there are other planning issues that may come up. I won't spend a lot of time on them in this presentation, but in terms of thinking about pet trust, charities, other things, those may be things that come up in your estate planning. So let's get our hands dirty. Let's talk about some of these documents. The first one is the healthcare proxy. I'm not going to go with the will first. That's the big and obvious one, because I want to make sure that everybody is mindful of the importance of these, what I call ancillary documents. What does the healthcare proxy do? Well, as I'm reading from my own slide, it's a document that designates another person basically to make decisions for you. And this is true whether you're at the end of life or you're in the prime of life and you just happen to be under general anesthesia because you're at the dentist. Am I on the right slide here? Okay, very good. So this person is going to make healthcare decisions for you. You want to choose someone good. And it's really less about picking a phenomenal doctor or someone who's been to medical school or works as a nurse. It's more about picking someone who is calm, good decision maker, and knows what your issues are. If you have a particular concern about a course of treatment, or if you're allergic to penicillin, pick someone who knows that about you and can be constructive in guiding your care, not only to make decisions for you, but also to have access to your medical file. If you don't have anyone like that in your life, don't just pick somebody and make it up. But if you do have people like that in your life, not only should you choose someone good, but you should also designate a second person in case the first is unavailable. See my prior comment about you just don't know who's going to be around. Um, Also important is the durable general power of attorney. This is a document that allows somebody else to sign your name. And by that, I mean sign your name for almost anything. A person with a power of attorney from you can sell your apartment, cash out your 401k, quit your job, apply for all kinds of benefits, all sorts of stuff. The only thing you cannot do with a power of attorney is vote or make someone's will. But other than that, it's fair game. So very much a blank check. So I don't see everyone do a general power of attorney. It's really typically for people who have a very, very trusted agent to appoint. That's sometimes married couples, an older person with a trusted adult child. I sometimes see it in unmarried relationships where partners have a joint balance sheet, but certainly not for everybody. And the main thing here is be careful who you pick. The living will, the third of our kind of core documents, is what I call the worst named document in the world. It's a document that says what's going to happen. Uh, Fix this. It's a document that says, if I'm in extremis, if I'm about to die, then I want medical care, but I don't want anything that's going to preserve my death. In other words, if the medical care is over and you're really just sustaining me either by artificial respiration or some other thing, don't do that. You may remember the famous Terry Schiavo case. And so this is a statement you make now while you're mindful about your end of life standard of care. It can be pretty flexible. You should say what you want. What I typically see people say is they don't want mechanical respiration, they don't want tube feeding, they don't want antibiotics. Again, all in the context of your final days, hours. It is not about being ineligible to receive care in the ordinary course. But if you're really um, in the final minutes, that this will allow you to have what some people call death with dignity. Not everyone does this. Some people, either for religious or philosophical reasons, don't want to have a living will, which is perfectly okay. But many people, particularly after they've seen a parent or an older loved one go through this process, want to make sure that once the doctors leave the room, the medical care ends. Um, so that's an important document. Okay, so let's get on to the main fight on the title card, the big one, the will. I have kind of a clever title here, Newsflash 1, because it really goes to the core of what I hope you take away from this presentation, right? Even if you don't have a will, if you have said nothing, the state is still going to do something with your property, right? You cannot opt out of dying and you cannot opt out of leaving stuff behind. So let's talk for a slide or two about what happens if you have no will. You have what I kind of, in a tongue-in-cheek way, call the state's will for you, right? And what does that mean? I'm going to use New York State as an example, and in most other states, Jersey, Connecticut, and then in the wider world, I don't know how broad our audience is. It looks something like this, right? And on first blush, this may seem pretty common sense to you, right? And these rules that have been around for centuries. If you have a spouse and no kids, spouse gets all. You have kids but no spouse, kids get all. Although, interestingly, the kids don't get it immediately. If they're minors, they have to wait until they're 21. But then problematically, they get it all when they're 21. So that's a pretty amazing junior year at college. Hopefully there will be a senior year at college. It's not clear. If you have spouse and kids, then the spouse gets the first 50 grand off the top. They also get the family Bible and enough feed for the livestock for 1 year. That's in the New York statute. But beyond that, the spouse and the kids split 50-50. This is actually a trap for a lot of people because what happens where you have minor children is that the spouse gets half the money, the kids then have half the money in trust, and it's relatively hard to access. So in a way, it cuts the resources available to the surviving spouse in half because the half that would go for the kids is now tied up in some trust account that the court is not going to want to use. It's meant to be saved for college. So the actual operating household expenses can be radically reduced if you fall into this situation. No spouse, no kids. Parents get everything. Parents aren't around. It goes to your siblings. If you're missing a sibling, then you get nieces and nephews. None of them. It goes to grandparents and aunts and uncles and cousins. And this is a sort of expanding concentric circle, a way of thinking about what you and I would call next of kin. Um, and that's not a crazy thing. It's the state's default rule for a reason. But what's bad about that, you ask? Well, let's take a look at this list and see who is disadvantaged by this, right? And you may have one or more of these issues. Life partner. If you are unmarried and you've been with a person for 20, 30 years, they put you through medical school, they're your best support, and you want to leave them a substantial legacy. If you have no will, they get nothing. The court does not care. That's why the marriage document is so important, because if that's not there, then when there's no will, that person takes nothing. Your friends will get nothing, no matter whether they've taken to kidney dialysis for decades, or they sort of clean your apartment every day, or they're just the best people in the world. They get nothing. Your relatives who are not in the priority list get nothing, right? So if you are survived by no spouse, no kids, and you have parents, your parents are going to get your money, even if they're comatose and on Medicaid. And it will all go to them and get sucked up by social services. And it will not go to your promising, hardworking nieces and nephews who are in college. So even in this case, relatives can get overlooked. Your pets will not get anything. The organization institutions you work with and support will get nothing. You can spend your entire retirement working for the Central Park Conservancy, and if you have no will, they will get nothing. Your business partners get nothing. And other people you might want to remember, either a loved one or someone who's been a caregiver, either to yourself or to your children, will get nothing if you have no will. So that's bad. So you should definitely have a will. Okay, so which prompts me to the second cautionary news flash. Even if you have a will, which I hope all of you will in a couple of months, it's not your whole estate plan. And by that I mean that the various assets and resources you may have that will need to be dealt with when you pass, it's not all covered by your will. Let's see why that is. Okay, when you are shuffled off this mortal coil, what you leave behind is your gross estate. And that's everything you own or could own or might as well own, right? It's the Broadway show tune you wrote, it's the book you almost finished, it's the business you built, the apartment you live in. It's all that stuff. Cash in the bank, the gold coins on your dresser, all of that. Your jewelry, everything, right? That's your gross estate. Now, your gross estate has two parts, right? And this is a little math equation. Your gross estate has what we call the non-probate estate. This is what passes by contract or by beneficiary designation. And then you've got your probate estate, and that's everything else. And the probate estate is the stuff that goes through your will. And that's important to keep track of because you want to have a will and know what it controls. So the non-probate estate, right? This is the stuff that operates under law or by contract terms, right? Life insurance, classic example of this, right? You fill out a life insurance policy when you're, young and flush and feeling good about things. You name a friend, you name your aunt or your mother, and then you do nothing. You go on to have kids or do other things. That life insurance contract is still going to pay out to whomever you named. You buy some life insurance when you're married and get divorced. Even though you're divorced, life insurance is going to pay out to that ex-spouse. Not good. You got to keep track of that. IRA, 401k, qualified funds, all of that stuff. Not always, but most of the time, will have a beneficiary named in the account of the contract, and you got to keep track of that. It does not change just because you write something different in your will. Joint accounts, like a bank account, if you have one with your sibling or your parent, that's jointly owned. Trusts are a common example of this, right? You may be in a family situation where you have some kind of somebody else created a trust and you have a power to determine where that money goes. That's technically your asset, but you can't, it's not going to pass under your will necessarily. And then just other kinds of property, real estate. If you own real estate jointly with a sibling or a friend or your spouse, and you die under the terms of how you own that real estate, it'll pass to that other person. So why is that relevant? Your will has almost no control over the stuff we were just talking about. The exception of that is pretty narrow. If your executor needs to collect money to pay taxes or other administrative expenses, literally your tombstone, they can technically claw it out of non-probate assets. But for the most part, your will is going to operate independently of all the stuff we were just talking about. Your will covers your probate estate, and as I said in my earlier example, my equation, your probate estate is everything else. And here it is again, right? You've got your gross estate, everything in the universe you own or control could be taxed on. You take out the stuff that has a beneficiary designation uh, in the account or in the contract, and then that's the stuff that your will is going to allocate, your so-called probate estate. So here's the bottom line. This is the takeaway from our presentation today. We're not done yet, but I'm just telling you this is the most important piece. I hope you write this down if nothing else. When you go to do your estate planning, do it around your gross estate and not just your probate estate. Doesn't mean you should go out and change your beneficiary designations. If you've got a IRA that names your spouse, you don't have to change it. But when you're doing your will, just be mindful that you've got that part of your estate controlled by that document, right? If you want to disinherit, one kid, or if you want to leave a little extra to one kid, either disinherit the one kid because he's a bad boy, or leave extra to another because, he's an artist or, he's had special needs issues. Um, that's the way you're going to do it. So you're going to plan around that. Okay, so news flash number 3. You've gone out and you've understood now what your gross estate is, and you've allocated it by having a will. You got to worry about estate taxes. Now, I don't have it on the slide because it changes from year to year. But this year, the federal estate tax exemption is 5.45 million, right? So you're not going to owe anybody any. You're not going to owe the federal government any estate tax unless you have more than 5.45 million personally, and if you have a spouse, if the two of you together have 10.9 million. And if you don't have 10.9 million, then we have that in common. So the federal estate tax is affecting fewer and fewer people. But it might affect some of you, and it's not uncommon to see people who have a lot of life insurance, or they've inherited substantial amounts, or they have been involved in some kind of cause of death that leads to a lawsuit. That might also cause them to have money that they didn't expect. It's very frustrating to not have a lot of money while you're alive and then suddenly have it when you're dead, and then all of a sudden it gets taxed. So the federal exemption is 5.45 million per person. And in our federal system, the states can also tax you. And I put New Jersey at the top here because this is the one that people miss so often. New Jersey will levy a tax on your estate if you have more than 675,000 individually. And that affects a lot of people, a lot of folks in New Jersey who are good savers. They pay their mortgage, they own their own home, they invest into a 401k, IRA, and they're just going about their business, building wealth. Many of those people have more than 675,000 and they face estate tax exposure. Doesn't mean they should give it all away, but it is something they want to plan around. New York has a much higher exemption. That right today is 4.2. It's going to change on April 1 of next year. And then April 1 of 2018, it's going to change again and rise to match the federal exemption, which is, as I said before, 5.45 million. So if you're a New Yorker and you got $5-6 million, you may not feel very rich, but you're an estate tax payer. So that's a piece that may go up to our friend Mr. Cuomo in Albany. And again, New York, New Jersey, Connecticut, like the federal government, these are per person. And so if you're a married person, you will have double that amount as a couple. Connecticut is sort of the Goldilocks. It's in between the two. It's 2 million per person. And plenty of folks, if you own an apartment that's appreciated or a house that's appreciated over the years, you have a little bit of life insurance, you've saved for retirement, you may well be at or above that number. Doesn't mean you're going to do anything differently. You may still leave your estate to your 3 kids, but you're going to want to think about those estate taxes. And last reminder, this is about your gross estate, right? It's the whole number. So your taxable estate includes your 401k, your IRA, any life insurance you have. That all goes into the top line number. Okay, so you're going to go out and get a will. You say, George, I need to do this immediately. Fantastic. Well, here are some drafting tips, whether you work with whomever, Quicken Will Maker, or your college roommate. When you go see an attorney, remember this: nominate good fiduciaries, not bad ones. Seems obvious, but people make this mistake all the time. And by fiduciaries, I mean the people in your will who are going to get an assignment to do something, right? Your executor is going to marshal your assets, pay your expenses, and distribute the money. The guardian, if you have minor children, is going to become the guardian of your minors. And the trustee, if there is one, is a person who's going to hold money in trust for another. Certainly, there will be one if you have minors, but you may want to leave money for the care of your parents or another loved one, and not give it to them directly. The classic example is parents who are on Medicaid or have other financial challenges. Don't leave the money directly, leave it in trust. And if you're going to have a trust, you want to have a good trustee, which is not necessarily someone who's an attorney or someone local, but rather someone who's going to follow the instructions in your will and do a good job. Seems obvious, but I see people all the time like, well, I think I'm going to name my brother in law. He's an attorney. And I say, do you like him? They're like, no, he's a jerk. And I say, well, don't name him. So you get it. Make sure you name enough of them. See my opening point. Everybody you know and everyone you name in your will is going to die. You just don't know what order. So sometimes people say, "Oh, my sister is going to be the guardian. She'll be fabulous." And I say, "Well, what if she's not around?" And they're like, "Well, what do you mean?" I said, "Well, if your sister's not around, who's going to be the backup guardian for your kids?" They're like, "Well, I haven't thought about that." And I say, "Well, that's your homework. Go do that." So make sure for all of these different roles, you name a backup and possibly then a second successor. This can be hard. I'm not pretending it's easy. If you don't have a lot of good choices, you may have to make some tough decisions. But certainly make sure you've got a little bit of a roster there. You don't need to name an entire baseball team. You don't need to go nine deep, but make sure you cover those bases. And same thing with the beneficiaries, right? If you say all to spouse, then to kids, what if your spouse and kids aren't around? Or, let's say you're unmarried and you have two adult children. You can say give it equally to them, but what if they're not around, right? You want to make sure that you have a will that is going to be flexible enough to deal with situations that are unfortunate that you don't anticipate. Um, so, as I said before, everybody you know is going to die, and you don't know the order. Name plenty of backup beneficiaries. You don't have to name 1,000 backup beneficiaries because then your estate executor is going to be dealing with all kinds of folks. But make sure you got enough backup plans there to cover the bases. All right, so those are drafting ideas. What else do you need to know to be a good will drafter? These information tips. Have a good sense of your balance sheet, right? In particular, people sometimes miss digital assets. But if you left a 401k 3 jobs ago because the HR person, was on leave, identify that. Don't make your executor do all the work. If you have an Etsy account where you sell some stuff and there's a little bit of money there, you need a password to get into it. Identify it. That's all good common sense. It does not need to be a co-op application. You are not, getting vetted for level 6 security clearance. So don't feel like, you want to go see an attorney about a will, but you haven't assembled, 5 years of dry cleaning receipts. It's not about that. You want to have a general idea what your balance sheet is, but you also want to make sure that there are no hidden or hard to find assets. Second point, some people are not mindful of this. So I'm going to flag it for you now. Have a good sense of what your family tree is, right? You don't have to leave stuff to your half brother, but you want to make sure that your executor can find out, where he is, right? And for parents, you want to be able to say not only their dates of death or if they're alive, who they're married to, but also prior marriages. The courts are super fastidious about closing off any possibility of other children, predeceased children, former spouses. So you want to make sure that your executor is ultimately able to say how many times your father was married and to whom and whether they had any children from those prior marriages. Every once in a while I deal with an estate where, it turns out the dad was married before, had a wife before my client's mother, and there's a predeceased child, and it doesn't affect the distribution of the assets, but it really slows down the process. So again, without becoming Sherlock Holmes, if you have this information ready to hand, it's very helpful. It doesn't mean you need to put it in your will, but you want to have it in a place where your executor can find it. And as you may know from your own lives, the people you see every year at Thanksgiving, your aunts, uncles, grandparents, uh, they have information that they may not think to write up and give to you, but when they're gone, you're going to be like, why didn't I ask my grandfather about, these other four people and where they are and where they came from? Anyway, you get it. It's important to know your family tree. Other stuff I kind of hinted at before, really kind of beyond the scope of a presentation like this, but things that you may want to think about because most good estate planners are deeply agnostic about their clients' concerns. So if you have an interesting asset or a pet or some other issue, feel free to raise it. Here are a couple that I see a lot that require a little bit of special drafting. Um, Pets. It is perfectly okay to say, I want my cat to go to, my neighbor or to my sister and leave a little bit of money, right? Pets are expensive. You got food and they got to have vet visits. So if you got a cat that's got another 5 years of life, $5,000-$10,000 is not a crazy thing to leave to your friend who's going to take the cat. Dogs are even more expensive, and it's not a big Leona Helmsley to do. It's perfectly okay to have a paragraph or two about what you want to have happen with your pets, um, and I do that quite frequently. I'm happy to do it. Persons with special needs or who are receiving government benefits, a lot of those benefits are tested by, well, means. By that I mean their income or their wealth level. A lot of these programs are available. Medicaid is the big one, but other programs for people with disabilities are eligible for people who can't afford their own care. So if you leave them a bunch of money, it's going to interfere with their benefits, and that's bad. And there are ways to draft around that. I say SNT here because that's sometimes called a supplemental needs trust or a special needs trust. So even if you're not replacing someone's benefits, you can provide for money for better room, physical therapy, cosmetics and magazines, visits from loved ones. Those will not affect their eligibility for benefits, and it's a way for you to include them in your legacy. Listen, I live in New York. There's a lots of people you look around that are not U.S. citizens, and they're great people, and they're married to people who are U.S. citizens. And there's some special estate plan that needs to go there. I think you should marry the person you love, regardless of their citizenship. But if you do marry a non-U.S. person, um, tell your estate planner because it's important to kind of address some issues there to keep the taxes low. Last point, there's a lot of wealth in this country that may never be realized because people may not cash in on their insurance policies, but those pay out every year. And if you've got a lot of life insurance, either through work or through that you own directly, then you may want to get, here I say ILIT is the acronym, but that stands for Irrevocable Life Insurance Trust. So these are all kind of planning notes, but ultimately, as I kind of close on this slide, when you go to see an estate planner, whether it's a financial advisor or an estate planning attorney, or you're just talking to your spouse or your loved one, it's all about custom tailoring. Raise the issues that you think are important. The best client for me is a person who has a crisp idea of what they want and is able to ask questions about the stuff they don't understand. So let your flag fly when you go to do this project. Okay, that's it for me. I am a good-looking man. There I am. That's my contact info. I've wrapped this up. Since I have no more slides, I thought we might take a couple questions, and I'll give the baton back to Maggie for that.
Great, thanks, George. We had some questions come in, and just a reminder, if you have a question now, you can use the chat box or email info@savvyladies.org and start with the first question, which is, where can one get a healthcare proxy?
Oh, great question. It turns out since the invention of the internet that all kinds of stuff are available online, and this is a classic example. This is very much a state by state thing, but if you go and search your state's either government departments for sometimes it's a health department, sometimes it's a department dealing with aging, and many hospitals will also provide healthcare proxy. There tends to be a very specific state form you can use, and they try to keep it short, but that should be available online without too much trouble to find it.
Okay, great. And this next question came in during your slide about wills, and it is there a difference for half siblings?
Great question, and it's a state by state answer. In New York, a half sibling is the same as a full sibling. So if you if you say to all of my siblings, the half sibling would take a piece. And even if you don't give them anything as a half sibling, they're still entitled to be aware of the probate process if they're among the next of kin. But that's very much a state by state thing. I can't speak to what other states do. I think the trend is to treat a half sibling as a full sibling, um, but that's certainly something you want to explore.
Okay. And the next question is, if my estate is basically just 401ks and money in the bank, if I have beneficiaries listed for each, do I need a will? I'm single with no children.
Lawyers answer. It depends. That will be enough to dispose of all of your money. But what it won't do, just having beneficiary designations and account beneficiaries, it will not name an executor. And so you might want to have a will nevertheless, just to name an executor, because you don't know if there's going to be a lawsuit involved in your death or someone to, deal with other issues that come up. If one of these accounts has an issue with it, like you need to, chase your employer for your 401k because they've just gone through bankruptcy or a merger, it might be the person who's the beneficiary, but it'd be better to have an executor who's appointed to do all that stuff. So that's one good example of why you might want to have a will, even if all your assets are have beneficiaries designated for them.
All right. Next question here is, I have a small blog. How can I add that to my trust?
Well, it could be as simple as your trust will have some kind of Schedule A or list at the back of assets that are owned. And so you might simply say, all of my right, title, and interest, everything I own related with my blog. And if your blog has created, intellectual property rights, copyrights, other things, then by identifying it as part of your trustee would be able to deal with it. Um, and you could also do that with your will as well. So that's a good example of non-tangible property that you may want to mention in your will. Great question.
Okay. And the next question is, what if after my husband, the next person is a permanent resident and not a citizen? Would that be a problem?
Well, none of it's a problem per se. The better way to say that is there's no special drafting you need to do. The whole issue of non-citizen spouses is a concern because they may not get a deduction against federal estate tax if they're a non-citizen spouse. But for any other beneficiary that's a non-citizen, beyond the spouse, they're entitled to take it free of any kind of inheritance tax, and your estate, if it's large, may pay an estate tax. So the short answer there is it's not a problem. It just, if you have a non-citizen spouse, there may be some drafting opportunities to kind of maximize your savings.
Okay, thanks. And next question is a will made with LegalZoom okay?
Lawyers answer, it depends. How good a car do you need, right? If you have a relatively simple, family structure, and relatively, easy to identify assets, then a good will from LegalZoom, if you, make clear decisions and you are very careful about executing it the way they say, and all 50 states in the union, you need to have two witnesses. It is not just a notary. But if you, pay attention on LegalZoom, if you're good at following instructions and you fill it out and you follow, their steps for getting it executed, that's perfectly appropriate for a lot of people.
Okay, and I believe this is the last question we have. It's, if a person has been married 2 times and had children from both marriages, are the kids from those marriages equal under the law if there's nothing differentiating them in a will?
Great question, and the answer is yes. They would all be equal. If your will says to my children, then any person that is your child is going to take equally with every other person that is your child. There are some interesting, things that get involved where you have adoptions, particularly adoptions of older children. Some states treat a person adopted, above age 21 differently as a child, but all of the natural children, regardless of who the other parent is and whether it's in a marriage or out of wedlock, they would all be children entitled to inherit.
Okay. Well, I want to thank you, George, for a great presentation. Those are all the questions we had, and I want to thank everyone for asking some really great questions today. and we hope you'll be joining us again. Thanks so much, George. It was really, really great.
Oh, I was so happy to do it. I hope everybody enjoyed it, and thanks for the opportunity.
Thank
Signing
you.
off. Bye bye.
Bye.